I would like to explore the tension between the theory and practice of Jus Cogens with a particular focus on the prohibition of the use of force and the legal challenges arising from Russia's aggression against Ukraine. I have divided my presentation into two main parts. First, I will outline the key findings of the International Law Commission's draft conclusions on Jus Cogens. Then I will focus on how Russia's aggression against Ukraine challenges the enforcement of Jus Cogens norms, what it means for the future of international law, and why it has led to proposals for a special tribunal for the crime of aggression against Ukraine. In short, here today, Russia's aggression itself serves as one of the most rigorous tests of the credibility and effectiveness of the theory of Jus Cogens. As a starting point, it is important to highlight that international law has undergone a significant paradigm shift. In other words, it has become increasingly human rights-centered, individual-centered, so to speak. So the very premise of my research is that, and it was also articulated by the International Military Tribunal at Nuremberg, that the provisions of international law can only be enforced by punishing individuals, because crimes against international law are committed by men, not by abstract entities. So in this sense, Jus Cogens is doctrinally linked to the Nuremberg principles. And if you look at the list of the Jus Cogens norms identified by the International Law Commission last time, that we can clearly see Jus Cogens norms overlap with the legal category of international crimes. So we are entitled to say that the evolution of individual criminal responsibility was therefore a necessary precursor both to strengthening the theory of Jus Cogens and to the practical application of these imperative norms. And I always add to this that these crimes and those who commit them literally embody and personify the theory itself. Let us see the theory of Jus Cogens. What exactly is wrong or problematic about the doctrine of Jus Cogens? Because it is well known that numerous criticisms surround the theory. Many of these criticisms stem from the fact that the doctrine has natural law roots. And we might know that natural law is tied to the infinitive search for the sources of the moral values safeguarded by Jus Cogens. However, because we do not have epistemological access to these metaphysical questions, Jus Cogens often appears uncertain. And as many positivists, such as Carlo Foccarelli, have argued that these norms are so-called quasi-law, quid pluris. Of course they are existing, one believes in them, but they are not part of positive law. So the first task for me was to remove these metaphysical questions, metaphysical burden from the theory. Though it was not so difficult since Jus Cogens entered positive law in 1969 through Articles 53 and 64 of the Vienna Convention on the Law of Treaties. And as Jean beautifully explained, principles such as the prohibition of slavery and genocide also entered positive law, but without losing their character as fundamental dictates of the universal conscience. So the central problem was not the moral values themselves, but rather the fact that there were no clear criteria or methods for identifying peremptory norms. But of course, based on Article 53 of the Vienna Convention, we can identify the very first major legal effect of Jus Cogens, namely that it limits the legislative power of sovereign states. However, because of the vagueness of the definition and the absence of a clear methodology, Jus Cogens largely remained at the periphery of international law till 2022. This is precisely why the ILC's draft conclusions on peremptory norms are so important, because the draft conclusions introduce two major achievements in this regard. First, they established the previously missing demarcation criteria. Second, they clarified key concepts contained in the definition of Jus Cogens. So according to the ILC, identifying a Jus Cogens norm requires a strict two-step process. First, the norm must constitute a rule of international law, obviously. Second, it must be accepted and recognized by the international community of states as a whole. But this immediately raises an important question, as Prosper Weil famously asked in 1983, who or what is this community? According to the ILC, the phrase as a whole requires a very large and representative majority of states. And the draft conclusions illustrate this through examples such as Buell versus Mitchell, where the court held that the prohibition of the death penalty had not attained Jus Cogens status because only approximately 32% of states had abolished it. Importantly, however, majority does not simply mean a numerical majority. It is not a mechanical process. The special reporter Dire Tladi provided us a very good example demonstrating why a quantitative assessment alone is insufficient. First, let us imagine Rule X. Rule X is expressly supported as opinio juris cogentis by 180 states. However, several major states with large populations object to its Jus Cogens status. Now let us imagine another rule, Rule Epsilon, or Rule Y. Rule Y is explicitly supported by only 120 states. But whenever the rule is discussed publicly in forums, debates, or diplomatic correspondence, no state has ever objected to its Jus Cogens status. As a result, despite having fewer supporters, Rule Y may actually have a stronger claim to Jus Cogens status because of the absence of objections and the broader support surrounding it. Thus, the answer to whether recognition by 120 states is sufficient for a rule to attain Jus Cogens status is, it depends on. In some cases it may be sufficient, in others it may not be. During my research, I applied this methodology and I argued that not only the prohibition of aggression, but also the broader prohibition of the use of force has attained Jus Cogens status. However, one of the most important questions yet to be answered regarding the theory, and it is the relationship between Jus Cogens and the so-called ergomness obligations. As I mentioned at the beginning of my presentation, that modern international law has become individual-centered. But Jus Cogens can still only be fully understood within the framework of state sovereignty, state responsibility. So for the sake of simplicity, I tried to illustrate this in a figure. And as we can see and might know, it's obvious that states as an abstract entities cannot commit international crimes. They can violate Jus Cogens norms only through individuals. So the state responsibility may arise in two ways. First, if the conduct of individuals is attributable to the state because it was committed by its state officials, as it would have been in the Yerodia case if the ICJ had jurisdiction. Second, if the state breaches its ergomness obligations by failing to prevent or punish violations of Jus Cogens norms. And if a state in question seriously breaches its ergomness obligations, like Russia, for instance, serious meaning a gross or systematic failure by the state, that triggers obligations for third states under Article 41 of the Articles on State Responsibility. And this in the second dimension, these also called ergomness obligations. Why? Because all states have a legal interest in bringing serious breaches to an end. However, these ergomness obligations in the second dimension does not itself create or impose substantive obligations on third states. So it is very important to examine the legal status of Article 41 of the Articles on State Responsibility. And in the context of Russia's aggression against Ukraine, the meaning of Article 41, paragraph 1, namely the obligation to cooperate, has now crystallized. So now, in the context of Russian aggression, we know exactly what this obligation means. It means institutionalized cooperation through international organizations, through UN resolutions adopted with overwhelming support. In other words, state practice and opinio juris increasingly support the customary status of obligations to cooperate through lawful means in response to serious breaches of Jus Cogens norms. And this is quite important because it has a direct connection to the Jus Cogens theory. And I also have to add that many cases, sadly, only third states have the capacity to redress somehow, such violations when the primary state fails to fulfill its ergonomous obligations. Why? Why only the third states? And here comes the evergreen dilemma. Because Jus Cogens is a substantive primary norm, and jurisdictional immunity is a procedural secondary norm. They are different classes of norms. Consequently, there is no legal conflicts arises between the two, so the Jus Cogens supernorm simply cannot override procedural rules, cannot override personal immunity. And as Gentian also mentioned in his article, that the separation between procedural and substantive norms essentially eliminates the possibility of accessing justice. And there are classical cases where the decisions of international courts have confirmed that there is no mechanical link between the primary norm and the secondary norm, like in Germany versus Italy case. And even today, it seems that the personal immunity remains absolute, even before international criminal courts. But, despite of this, international criminal courts have recently issued several arrest warrants, calling on states to arrest individuals who would otherwise enjoy personal immunity. Notably, ICC, the International Criminal Court, issued arrest warrants against the Russian President Vladimir Putin. So it means that international courts are increasingly testing the limits of personal immunity, especially when prosecuting individuals accused of Jus Cogens violations. So it is a plausible question to ask, is there now an exception to personal immunity? We have a case that offers some degree of clarification on this matter, the Yerodea case, the arrest warrant case, where the court emphasized that, inter alia, that an incumbent minister may be subject to criminal proceedings before certain international criminal courts where they have jurisdiction. So the questions are, is the international character of the court by itself sufficient to defeat personal immunity? And if yes, under what circumstances? And if so, does the very fact that the norm in question has Jus Cogens status make any difference? We have an international criminal court, the ICC, and the Rome Statute was the first multilateral treaty to expressly waive the immunity of state leaders through Article 27. But there's a rub. Article 27 consists of 2 paragraphs. The first paragraph states that official capacity does not exempt a person from criminal responsibility. And the second paragraph refers to the procedural aspect, namely that official capacity does not bar the courts from exercising jurisdiction. And of course, Article 27, paragraph 1 reflects a customary rule. It is Nuremberg principle. And I must be noted here that functional immunity, for instance, can no longer be invoked before any courts in cases involving serious Jus Cogens violations. However, the same cannot be said of personal immunity. because there is still insufficient evidence that a general customary law exception to personal immunity has emerged for international crimes. Consequently, Article 27, paragraph 2 is still not considered a rule of customary international law. Its effect is therefore limited to states parties to the Rome Statute. Ukraine became a state party on the 1st of January 2025. Before that, jurisdiction rested on its 2014 and 2015 declarations under Article 12.3, but Russia is not a state party to the Rome Statute. So it is another plausible question to ask that if this is the case, then what can the ICC actually do with the arrest warrants issued against Russian officials, against Vladimir Putin? We have a case which can serve as a precedent, namely the al-Bashir case involving the then president of Sudan. Sudan, like Russia, was not a party to the Rome Statute, a state party, and al-Bashir enjoyed personal immunity, and Sudan had not accepted ICC jurisdiction either. But there was a significant difference between the two cases. In the case of al-Bashir, there was a Security Council resolution 1593, acting under Chapter 7 of the UN Charter, and that Security Council referred the situation in Darfur to the ICC. And this resolution provided the legal basis for the court's jurisdiction, and this very resolution eliminated al-Bashir's personal immunity. There was a huge legal dispute, though, regarding this case, because one of the judges regarding the Jordan decision argued that Article 27 is more than a stipulation in treaty law. By now, it also reflects customary international law. So, according to this reasoning, even without a Security Council resolution, al-Bashir would not have enjoyed personal immunity before the ICC. However, this reasoning was highly controversial, still it is. And, for example, Dapo Akande described it as a very dangerous and unwise move for the court to make, because this reasoning appears to suggest that states parties to the Rome Statute, by creating the court, effectively took away the rights of non-party states under international law. So the upshot is that regarding al-Bashir, only the Security Council resolution 1593, provided the necessary legal basis for overcoming personal immunity. During my research, I also found that in the course of the discussions regarding Resolution 1593, most states also considered in general that the Security Council resolution acting under Chapter 7 of the UN Charter to be the only effective means of removing the personal immunity of incumbent leaders. So as a result, no general exception to personal immunity has crystallized yet. Consequently, leaders of non-state parties like Russia sadly continue to enjoy full personal immunity before treaty-based courts such as the ICC, even when accused of Jus Cogens crimes. And we have seen also that regarding the theory of Jus Cogens, there were no cases with a direct effect of peremptory norms or of personal immunity. However, I argue that Security Council resolutions can be viewed as a quasi-positive obligation, or better to say responsibility, grounded in the gravity of Jus Cogens breaches. I describe this as an indirect effect of Jus Cogens operating through the Security Council. Of course, unfortunately, due to Russia's veto power, the adoption of such a Security Council resolution is impossible, thereby precluding the referral of the situation to the ICC. Since Russia's invasion, the question of individual criminal responsibility for the crime of aggression has returned to the forefront. Many international scholars agree that those responsible should be prosecuted specifically for the crime of aggression. And the charges for war crimes and crimes against humanity must not serve as substitutes. The reason of this, and I truly agree with Klaus Gress, that the Russian aggression brings to mind the interwar period when the prohibition of war, the Bryant-Kellogg Pact, lost its authority in the 1930s because states failed to sanction early violations, like the violation or the invasion of Manchuria. And today, if the crime of aggression is not prosecuted separately, then the authority of prohibition of the use of force is at stake. The problem is that regarding the prohibition of aggression, the situation is even more difficult, because even though Resolution 3314 provided the definition of an act of aggression, and even though aggression was listed in the Rome Statute, this existed only formally for a long, long time. Okay, finally, the Kampala Amendments provided a definition of the crime of aggression and established a jurisdictional framework. And they also clearly distinguished between the act of aggression committed by a state and the crime of aggression committed by an individual. But of course, these two are intertwined. The act of aggression is the sine qua non of the crime of aggression. But the problem is that regarding aggression, the ICC has a so-called sui generis jurisdictional regime, which remains highly restrictive. It means that both the state in whose territory the act of aggression is committed and the state whose nationals are the author of the aggression must be parties to the statute and must also have ratified Kampala Amendments. To date, only 47 states did so. And some paradox arises here as well, because the individuals whom can commit the crime of aggression, namely political or military leaders, are also those most protected by sovereign immunity. And if this were not enough, there are also practical difficulties. There is no precedent, because since the Nuremberg and Tokyo tribunals, no state leader has ever been tried before an international court for the crime of aggression. Yes, of course, there were a few domestic cases, such as those involving Viktor Yanukovych and the Hungarian László Bardossy, but not before international tribunals. So, as Antonio Cassese observed, the crime of aggression has effectively fallen into oblivion. Then what can we do regarding the crime of aggression? Many scholars and states agree that the solution must be the establishment of a special tribunal that would ensure that those most responsible for the aggression against Ukraine are held accountable. The most likely suspects would be the so-called Troika: Vladimir Putin, Sergei Lavrov, Mikhail Mishustin, as well as Alexander Lukashenko, the president of Belarus. Regarding North Korea, at this stage we still do not have sufficient evidence. But regarding the tribunal itself, the key question is the following. How can a special tribunal for the crime of aggression against Ukraine be established in a way that is sufficiently international and ensures that incumbent leaders do not benefit from personal immunity before the court? Several models have been proposed. The first one is the UN General Assembly model, the second is a Council of Europe model, and the third is the Nuremberg model. The first one, the UN General Assembly model, which was established through an agreement between Ukraine and the UN General Assembly, is often considered the most legitimate because it would enjoy broader international support. And the Special Court for Sierra Leone has also been mentioned as a relevant precedent for the possible creation of a tribunal on aggression against Ukraine, because the Sierra Leone Court was established in 2002 through an agreement between the United Nations and the government of Sierra Leone, and it prosecuted the then librarian President Charles Taylor. Importantly, this occurred without a Security Council resolution. So it seems like a good precedent, but if we look closer, we can see that Liberia cooperated with the court, or at least was not an obstacle. And there was also a Security Council recommendation 1315. Okay, it is not a resolution, but still. So in sum, as we can see, under the current legal framework, Russia would not be legally compelled to cooperate with such a tribunal, and the Troika would likely remain immune as long as they remain in office. The last time I checked, the Council of Europe model, so the second model, appeared to be the most likely option, and the formal work is expected to begin sometime in 2026. Because of this international deadlock, scholars and states have increasingly focused on alternative solutions. One proposed venue involves the so-called Uniting for Peace resolution. So given the Security Council's inability to discharge its duties due to the Russian veto, other council members resurrected this very resolution. The option would be, what if, with a broad interpretation of the General Assembly powers under the Uniting for Peace resolution, could potentially confer upon the Assembly, when the Security Council is blocked by a veto, to authority to create a special tribunal binding all UN members, would be similar to the ICTY and ICTR ad hoc tribunals, or even better solution, refer the situation in Ukraine to the ICC. The problem with this solution is that this is a dangerously broad interpretation of the General Assembly's power. So it's considered ultra vires because the General Assembly lacks of authority to take coercive or enforcement action. And so far, it seems that only a Security Council resolution could, in principle, resolve the issues. But the problem is that Russia is a permanent member of the Security Council, and Russia will probably continue to exercise its veto power in the future. That's why the international community has increasingly sought ways out of this international deadlock and has therefore focused on reform efforts concerning the veto power. But regarding the veto, the only achievement so far is that the General Assembly adopted a resolution which established a standing mandate for a General Assembly debate whenever a veto is cast in the Security Council. In short, this resolution focuses on requiring permanent members to explain their decisions before the Assembly after using their veto. However, of course, it does not affect the legal validity or existence of the veto right itself. And many scholars, such as Ann Peters, argue that the veto cast by a permanent Security Council member to shield its own act of aggression may constitute an abuse of rights and a violation of the Charter's good faith requirement. And Article 27, Paragraph 3 of the UN Charter also requires a party to a dispute to abstain from voting. Therefore, a veto cast in violation of this duty, especially when a Jus Cogens norm is involved, could potentially be treated as an abstention. I think it is a plausible argument and also based on Jus Cogens, but it also represents a very broad interpretation of international law, so it is legally problematic as well. And this brings us back to the central paradox of Jus Cogens. Of course, Jus Cogens, if Jus Cogens were accorded independent legal force, just only because it protected moral values, but without a solid empirical basis, state practice opinio juris, that is outside the methodological framework of international law, then the rule of law would be at risk. The stability of the international legal order would be at risk. And we have seen that the example of the crime of aggression illustrates the paradox as well, because despite its Jus Cogens status, it provides even fewer avenues to challenge jurisdictional immunities than other peremptory norms because of the sui generis jurisdictional regime. So the question is then that can Jus Cogens have concrete legal consequences at all? My answer is yes, because no matter how rigorously the theory is tested, at least 5 concrete legal effects can be identified. I identified inter alia the so-called sanctioning function, and it is very important since it has a direct connection to the theory of Jus Cogens. We've seen that under Article 41, Paragraph 1 of RCWA, third states have an obligation of institutional cooperation, primarily within international organizations, to ensure a credible collective response to serious Jus Cogens breaches. And there is another effect. I called it indirect effect. That's a positive responsibility of the Security Council, which can transform Jus Cogens demands into concrete obligations through its resolutions. And finally, I identified the last effect, the so-called downward causality of Jus Cogens, because I argue that Jus Cogens constitutes a strongly emergent and objective legal category. So once the norm reaches peremptory status, it can no longer be reduced to its doctrinal elements, to customary law treaties. And this status prevents it from being hollowed out even when systematically violated. And because the threshold for identifying new Jus Cogens norms is so high that the prohibition of the use of force has survived every major geopolitical upheaval. And it should also be noted, as Wittmann observed, that the framers of the UN Charter were pragmatic men, hardened by their experience of 2 world wars. So they knew exactly that a ban of the use of force could not eliminate all interstate violence, but it could reduce it substantially. And Article 2.4 has shown a surprising capacity to endure. So its core, the ban on invasion, occupation, and annexation, remained largely intact until Russia's aggression, because this is the first and the biggest full-scale invasion since the Second World War. That is why the impact of Russian aggression raises pressing questions about the future of international law. Could it reshape modern international law? Is this a new paradigm shift? Regarding this, there are 2 different predictions, the pessimistic and an optimistic one. The pessimistic view, based on Thomas Frank's famous warning about the death of Article 2.4 of the UN Charter, and some scholars argue that these concerns have now been fulfilled. According to this view, the prohibition of the use of force survives only in the paper world, while state practice has drifted away from genuine compliance. And there is an optimistic view, and scholars such as Ann Peters and Patrick Labda argue, or at least argued, that the shock of Russia's aggression could revitalize the dusty system of the UN and ultimately strengthen peremptory norms, as evidenced by the unprecedented level of international cooperation. But which of these perspectives will prove true remains a question for the future. Thank you very much.